Our Supreme Court cases were Vernonia School District 47 versus Acton and Board of Education versus Earls.
The cases were very similar. Both were about student drug tests, Vernonia for athletes and Earls for students with extracurricular activities.
This lawsuit was filed by the Acton family. They had a son, James Acton, who was in 7th grade at Vernonia Middle School. James wanted to participate in a sports team, but his parents didn't agree with the mandatory drug test, so they filed a lawsuit against the school. The Vernonia School Board argued that their student athletes had a long history of drug abuse, so they believed that the drug tests were an effective way of solving their students' drug problems. In order to play sports, they had to take a drug test, so the students would therefore not take drugs in the first place. Also, since the results of the tests were not allowed to be shared with the police, the school board said that they didn't consider this a privacy violation. The court had many contradictory rulings. The first ruling, done by the Federal District Court, agreed with the student school's policy. The second ruling, which took place in the appellate court, said the opposite and took the Acton's side. The third and final ruling, done in the United States Supreme Court, agreed with the school, finalizing the matter. Judge Antonin Scalia was the main supporting voice of the Vernonia School District. Scalia argued that the power a school has over its students is tutelary and guiding, so the school therefore has the authority to be more controlling of its students than any other organization could have over a free adult. Judge Scalia also said that since these students are athletes that are willingly participating in a school-run program, they have even less of a claim to privacy than normal students. This ruling fell in line with the special needs doctrine as well. The special needs doctrine is a law allowing drug testing on employees without probable cause or a warrant. To finish his argument, Scalia added that the drug tests were never submitted to the police, so there was little to no breach in the athletes' privacy.
In 1998, the Board of Education of Independent School District No. 92 at Pottawatomie County adopted the Student Activities Drug Testing Policy, which required all middle school and high school students involved in extracurricular activities to consent to random urinalysis drug testing. The policy was only applied to competitive extracurricular activities like cheerleading, band, choir, sports teams, and the academic team. The test detected the use of illegal drugs like amphetamines, marijuana, cocaine, opiates, and barbiturates, and not prescription medications. Lindsay Earls and Daniel James, both involved in extracurricular activities together with their parents, challenged the policy and argued it violates the Fourth Amendment, the right to privacy. Graham Boyd, an attorney for the American Civil Liberties Union, represented the students, seen in this picture, answering reporters' questions. They reasoned that the school district failed to identify a need for random drug testing or a history of drug abuse. The Board of Education argued that a student's privacy is limited when participating in school activities. Under the policy, a faculty member waits outside the restroom stall for the student to produce a sample and must listen for the normal sounds of urination in order to guard against Stanford specimens and to ensure an accurate chain of custody. The students stated the school had been careless in protecting their information. For example, the choir teacher looked at a teen prescription drug list and left it where other students could see it, which they felt violated their privacy. The Board of Education stated because of the Vernonia case and the high level of drug abuse nationwide, it made the war against drugs a pressing concern in every school. The school district presented specific evidence of drug abuse and said school teachers reported 18 students who appeared under the influence. They heard students speaking openly about using drugs, and a drug dog found marijuana cigarettes near the school parking lot. The school board stated it would make little sense to require the school district to wait for a substantial amount of students to begin using drugs before allowing a drug testing program designed to deter drug use. In a 5-4 vote against Earls, declared by Justice Clarence Thomas, the court upheld the policy as it fell within the special needs doctrine, an exception to the Fourth Amendment that allowed searches without a warrant or probable cause for purposes like administrative inspections or drug screenings. Both Vernonia and Earls cases rejected that drug testing violated the Fourth Amendment.